Welcome to the Jones Zone, a podcast by Darryl and JJ Jones.
Hello, everybody. Thanks for tuning in. Today, we've got the pleasure of having Steve Silverstein. He's an eviction attorney in Orange County. I've referred many clients to him. If you have a tenant that needs to be evicted, he is the guy to go to. Those of you that have not subscribed yet, please click on that subscribe button. It'll help get this video out to more and more people. So we're going to talk about the eviction process and anything that's new in the eviction procedures and everything. So let's go ahead and dive right in. What are the most common reasons landlords have to begin an eviction process?
Well, first, I'd like to thank you for inviting me to your podcast, and it's an honor to be here with you. The most common reason for eviction is non-payment of rent. Most tenants, that's 90% of what we get. Then you get the situations where the landlord wants to get the property back for no reason at all. Those are 30 or 60-day notices. The most common reason is non-payment.
Walk us through the process. So someone's not paying their rent. They call you and they hire you. What happens from there?
Well, first of all, when they call me up, they say, I'll start off. I'd like to take control of the conversation. I'll ask them, okay, what city is your property in? After I ask them what city the property is, I said, is your tenant paying the rent? If he says no, then I said, well, okay, the first thing that has to be done is a 3-day notice, pay rent or quit. Did you give one? If they say, yes, I did, I said, get a copy so I can ask you questions to see if you did it right. Because in unlawful detainer law, if you don't fill out your notice correctly, dot your I's and cross your T's, you'll lose your case. So the first thing I ask, hey, did you put anything on there other than rent? Late fees, bad check charges, security deposit, utilities? And if they say yes, then they have to start their notice down over again. Because the important thing is, the only thing that can go on a pay rent or quit for residential is rent. And a common mistake a landlord will make is putting something other than rent on, like a late fee or something like that. So if they say, yes, I did it, I will say, congratulations. The next thing I ask, did you put on your name, your address, your phone number, and the days and hours the tenant can pay you? Because that's required under California law. So I ask that question. If they say yes, then they say fantastic. The last thing I ask about the notice, I ask them, does your notice say within 3 days, excluding Saturdays, Sundays, and judicial holidays, you must pay the rent in full? Because the law changed a couple years or a year and a half ago that requires that you have on your notice excluding Saturdays, Sundays, and judicial holidays. Missing those 5 words, you will lose your case. So I check out the notice to make sure that what they say is true, and then I ask them how they serve it. So after they do that, if they say yes, then we can start the eviction process.
The laws kind of tend to protect the tenant a little more so than the landlord. Would that be fair to say?
Oh, absolutely. Over the years, I've been doing this for 46 years. Over the years, it has gotten a lot harder because the pendulum has swung over to the tenant side. It used to be pretty simple evicting tenants because there were no laws protecting them. Then the first big law came in was the Santa Monica rent control law, then the Los Angeles rent control law. And now, after COVID, all these cities are having their own rent control laws. So it has gotten harder. So you got to dot your I's and cross your T's to make sure you don't lose on a technicality, because there's a lot of law firms out there that will just extort the money out of the landlord and look for any wrong missteps that a landlord makes, and you'll lose your case based on a defect.
Long story short, they need to call you right away. I mean, I don't know. I would recommend for anybody to do this on their own. I mean, essentially, the sooner you get the tenant out of there, the sooner they can start collecting new rent. You kind of pay for yourself in a sense, don't you?
Right, you do. Absolutely. I check it out to make sure that they get it done. After the 3-day notice is done correctly, I think to answer the rest part of your question, then an unlawful detainer is filed. Proper term is for a regular eviction, an unlawful detainer. It's filed with the court. Most of the time, the filing fees are $240 plus the e-filing fees. If it's under $10,000, plus the cost of an eviction, which is the filing fee, the process server, the writ of possession, which is the order of the court, and the sheriff instructions who does the actual eviction, plus your e-filing fees. So an unlawful detainer is then filed, and it's e-filed. It used to be that the process server would take it from my office, go to the court, get it, stand in line, get it stamped, and then go straight and serve it. Now, with the advent of computers and technology, maybe about 15 years ago, it changed to e-filing. And they kind of got the bugs out of it, and it takes about a day or two in Orange County to get it back. LA County is a little bit longer. Inland Empire is about a week to get it back. So it depends on the court, depends how fast they go. After it comes back, then we give it to the process server, and he goes out and tries to serve the eviction. If he's successful, they have 10 days to file an answer, not counting weekends and holidays. It used to be 5 days up until April of this year, but that may change because the pendulum has swung further. The Democratic legislature and our governor, Comrade Gruesome, has changed the landscape for the landlord and makes the life harder for the landlord and helps the tenant stay in the property as long as possible on the landlord's dime.
Would you say pretty soon the landlord's going to have to be paying the tenant? I'm kidding.
Well, no, you don't say that because we'll get to that in a minute when you get to jury trials, because a lot of times the landlord has to pay the tenant to get out because it becomes a business decision. But I'll get to that in a little bit. After it's served, they have 10 days to file a response. A response can be an answer. If that's the case, that's a simple response. And you set the case for trial, and you'll have a trial within 20 days in Orange County. If they file what's called a demur or motion to strike or a motion to quash, those are delay tactics. 95% of the time, they're overruled, and then they have to file an answer. If they file a bankruptcy, then the whole eviction stops, and you have to go to bankruptcy court to get your stay lifted. But let's assume for a minute, to answer your question, the eviction process, that they do file an answer. Then as soon as we call the court or look on the website, as soon as we find out that the answer has been filed, then we go ahead and set the case for trial. And as I said before, it takes about 20 days to get a trial, to get into court for a trial.
A couple different questions here. You had mentioned previously about even the cities having things. So are there even more hoops that you have to not only get a county to do certain things, but you also have certain city rules? Is that fair to say?
Oh, absolutely. After COVID, everybody felt sorry for the tenant, and everybody got ahead. And a lot of cities, in Orange County, the city of Santa Ana has instituted rent control. The first one in Orange County to institute rent control. In LA County, you've got rent control ordinances in Pomona, city of Maywood, Bell, Pasadena has a rent control. There's a few other cities that all have rent controls. I don't have them all at my fingertips, but a lot of them have gone ahead and done that. The county, the unincorporated area of Los Angeles, they got on the bandwagon and they have rent control. So some of them are more onerous than others, but it's not as easy as it used to be to do an eviction, because they're teaching an old dog new tricks, because I have to learn all the law. I've stopped doing downtown LA because the city council in LA kept moving the goalposts. They kept changing the law and making it harder. And at this point, I said, that's it. I'm not going downtown LA anymore. I'm in Orange County.
It would be okay for me to mention, when I did first contact you and ask you to be on the show, you had said, sure, absolutely, I'll do it for you, but I don't want to do Los Angeles. And it's just because it was funny, because I was actually talking to someone about having you on my show and saying, yeah, he didn't even want to do Los Angeles because I don't think they know what the laws are in Los Angeles. It's so convoluted.
Well, they keep changing the laws. You got to keep up on it. And the city council has instituted new laws this year, and they're contemplating more. And it just makes it harder for a person to do an eviction up there. If I tell you what, if somebody offered me real property in Los Angeles for free, it's a rental, I refuse it, because getting somebody out is an act of God up in Los Angeles.
Wow. Well, let's go back to rent control. Tell us the pros and cons of these laws of rent control, in your opinion, your view.
Well, the state of California has instituted rent control for the whole state. Let's start with that. The state of California, for multifamily properties, has instituted a rent control ordinance for the state, meaning that if somebody's in there for over a year and it's a multifamily property, a duplex or triplex, apartment complex, or two houses on a lot, that is under rent control after 1 year. So a lot of people enter into rental agreements for 1 year. I always tell my clients, do not enter into a rental agreement for 1 year. Do it for 11 months, because if you have a term lease for 11 months, after the term lease expires, you can do an eviction based on the expiration of the lease. You don't have to give any notices. But once they're in there for 12 months, they're in there for life, unless they don't pay their rent, or if they don't violate a condition of the rental agreement, or if they don't create a nuisance. The only way you're going to get them out is relocation fees, if you are going to take the property off the rental market, or if you're going to move into the property, or you're going to do a major renovation to the property. And that law changed in April. It makes it much harder for the landlords to go ahead and evict them. Now you have to, on a renovation case for the state of California, you have to attach a copy of the building permit. And it has to affect the habitability of the premises, meaning electrical, heating, plumbing, and it has to be a major renovation that takes over a month, and it has to affect the habitability, and you have to put in there the scope of the work and the reason they can't be in there during the period of time. And and you have to attach a copy, like I said, of the building permit with the 60-day notice. And plus you have to give them 1 month relocation fees. If you own the property as an individual, a trust, or an LLC, and it's a house or a condo, then you're exempt. But then your governor, as I affectionately call him, Comrade Gruesome, has put another obligation on the landlord. You have to notify the tenant that the property is exempt. You usually do that in a rental agreement, which just has a rent cap and notice of exemption clause in it. If a landlord doesn't do that, then you should serve it along with your 60-day notice of exemption, which has to have the code section on it.
Wow. So a landlord just can't evict a tenant for no reason. There's late on rent. Now, if someone, for example, wanted to sell their property, they had a property, it was being rented out, and they wanted to do a 1031 exchange, or it doesn't even matter what they want to do. If they want to sell it, is that an easy process, or can that be challenging? I guess it depends on the tenant.
You can go, first of all, it has to be a month to month. If they've been there less than a year, you can give them a 30-day notice. If it's a multifamily property, the rights of the Tenant Protection Act doesn't attach. If it is a multifamily property and you have to rent out, if you want to sell the property, you're going to sell it with the tenants in there, because selling the property, you're selling it as a rental. Only if it's a house or a condo can you go use the excuse that you're selling the property and you want it vacant because you want to sell it, and maybe an owner wants to move into that property.
I think most of our listeners are probably on that. They own either a house or a condo that they rent out. So if they, let's say, own a condo that they rent out, and they go, we just want to sell it, so they just simply go through the steps of giving them a notice to. Would it be an eviction? Considered an eviction?
Well, you give the 60-day notice if they've been there over a year, or a 30-day notice, and on there you would have to put down, first of all, that the property is exempt. Hopefully, it's in your rental agreement. Or you can give a notice of exemption when you serve your notice, but you also have to put in there the property is being taken off the rental market and being sold. So that is one of the reasons you can give the 60-day notice. If you have a notice of exemption, you don't have to give relocation fees of 1 month to the tenant. And I'm just talking about the state. The city of Los Angeles has the Ellis Act, which I'm not going to get into. And city of Santa Ana, you have to give 90 days relocation fees. And then 90 days relocation fees or 3 months worth of rent.
You have to give it to them?
You can waive 2 months rent, and then within 15 days, when you after you serve it, you have to give them a month's rent. You have to give them 3 months worth of rent for relocation fees.
So I said that as a joke, and it's actually already here.
Oh, yeah. It's in Santa Ana? Yes, it is.
Kind of like cash for keys. I know when we were doing a lot of short sales and we had to get people out of properties, or not we, but people had to get out. They gave just what's called cash for keys. It's kind of a little bit like that, but that was by voluntarily done. But now it's mandated.
Yeah, when we get into jury trials, we'll talk about cash for keys.
Yikes! What are the biggest mistakes that landlords make when they're trying to evict a tenant?
Well, the biggest mistake is they fill out the notice incorrectly.
Tenants can really game the system if they
Oh.
know what to do.
Oh, absolutely. Gaming the system is part of the defense person pleasure. They know how to do it, and they look for any mistake because there's so many technicalities on unlawful detainer. And the reason you get to have these technicalities is because it's an expedited process. Instead of a regular lawsuit, say when you get sued, 30 days to file a response, you only have 10 days. It used to be 5 days, but now you have only 10 days. And so it's unlawful detainer is a creature of statute, meaning it was made by the legislature, and the rules are enacted by the legislature. And since there's a supermajority of Democrats in the legislature, it has changed dramatically in favor of the tenants.
If everything goes smoothly, let's say there's no fight, how long does it typically take you if someone was to contact you and get a tenant out? Is that usually done in when can they expect, again, with a tenant that cooperates, let's call it?
Well, let's say it's a default. Let's give an example. If it's Orange County, you're looking at probably a month for getting your judgment, three weeks to a month to get your judgment. Then you get your writ of possession. Then you give it to the sheriff. Now, the sheriff used to be pretty quick here in Orange County, and they used to get the writ of possession and within a day or so post a notice to vacate, and then 5 days later, they would lock them out. However, now in Orange County, there's two sheriffs, the Central Orange County Sheriff, which takes care of North Orange County and West Orange County, and then there's the South Orange County Sheriff, which is the Harbor Division, and they take care of all the southern parts, Costa Mesa, Newport, and Lake Forest, and San Clemente, Dana Point, and the other cities over there. They're quicker. The Harbor Sheriff only takes 4 to 6 weeks to do a lockout because they're so backed up. The Central Orange County Sheriff takes 4 to 8 weeks to do a lockout after they get your sheriff instructions.
Talk to us about what a lockout is for the viewers that don't know what a lockout is. That's when the sheriff department actually comes to the house.
Yeah, after you get your judgment, you get what's called a writ of possession. That's the order of the court giving you back your property. You take that writ of possession along with your sheriff instructions, which has cost $180. And the writ of possession is $40 plus $15 for e-filing fees. So you take that over to the sheriff, and they take it and they clock it in. 4 days later, they'll post a 5-day notice to vacate. At the end of 5 days, the tenant will vacate because they don't want to be, they say we're going to come back out there. But in reality, they don't come back out there right away. They come and they take their time because they're so impacted because there's so many evictions. They take 4 to 6 weeks in South Orange County to do the lockout after they get my sheriff instructions. And in Central, they take 4 to 8 weeks. That's how impacted. They send out 4 cars, and the landlord has to meet the sheriff there with a locksmith or a key. If the landlord meets them out there and doesn't have a key to let them in and they didn't bring a locksmith, then the sheriff will leave because the sheriff will not kick in the door. What the sheriff does, once they get entrance, they will go into the property, clear out the tenant, then the locksmith can change the locks. That's what it looks like.
You're talking about contents because we've had situations too, clients of mine, where let's talk about that. So let's say they get the tenant out of there and there are contents there like couch, TV, whatever. There are some laws that suggest or that say that the landlord has to store those?
Yeah, absolutely. The landlord has under 1984 of the Civil Code through 1988 of the Civil Code, the landlord has the duty to safeguard those items. The landlord has a duty to send a letter to the tenant telling the tenant at the last known address, which is the subject property. He has the duty to go ahead and say, hey, I've got your property. If you want to reclaim it, you can, but you have to pay the reasonable rental value per day to reclaim your items. So
the tenant has to pay the landlord for the rent for storing their stuff,
per
at
day,
least.
yeah, from the date of the lockout, not the back rent, from the date of the lockout. So if your rent's $1,000 a month, from that date, if he wants to get back in, the landlord can hold the tenant's feet to the fire and say, it's $33.33 per day. The landlord has to notify the tenant in writing that if you want to reclaim your items, it's $33, assuming the rent's $1,000. $33 per day. You call me up during regular business hours and I will open the door for you. Now, a big mistake is when the landlord opens the door and leaves, sometimes the tenants move back in. So if that's the situation, then you have to call the sheriff and show them your receipt and you can have them arrested. So you should probably have someone stay around to make sure they don't make themselves too comfortable in the property. A big thing for the landlord to do is once they get possession, they should go through their personal effects to take a look to see if there's a bank statement or a payroll stub somewhere, because inevitably they owe the landlord money. And this is their opportunity to find out where they work or where they have a bank account or any other asset. Because a lot of people get judgments for an eviction, but you can't collect them because the tenants disappear into the woodwork. The landlord, they change jobs. The landlord doesn't know where they are. And if you and there's one question that you probably should ask me: what should the landlord do to protect themselves? And we'll get into that in a minute. But that's what the tenant should do, or the landlord should do when they get possession of the property. Then the landlord has to go ahead after he writes that letter. They have the letter should state you have 15 days to reclaim your items. It's $33.33 a day if it's $1,000 of rent. Contact me. Here's my phone number. And at the end of 15 days, I'm going to advertise twice in a 2-week period, 5 days apart. Then I'm going to have a sale. I'm going to sell your items to the highest bidder. So and then a lot of times that's a garage sale, but that's what you do for items left in the property. Now, the common misunderstanding is that the tenants will leave their stuff in there and the landlord says, well, I don't want to move the stuff out. He'll leave it in there because the landlord has a right to move it out and put it into the storage, which is probably the smart thing to do so you can get your property fixed up again and re-rent it. So if you do that and you leave it in there, I have phone call after phone call after phone call. They call me up and said the tenant broke the window, got in, and started moving their stuff out. And, then you get damage because a lot of times the tenants, they don't have money. That's the reason they didn't pay rent. Will break back into the property. So that's a problem you have if you do that. If you don't want to move the stuff out, because you can charge them, by the way, if you do move it into storage, you can charge them for the cost of moving, the cost of storage, and the cost of transportation to that storage unit. So you can do that, but and otherwise it's on your dime. So the other thing you might want to do is make sure that if you do that, you tell them that it's being storage and how much it costs to store it and how much it costs to move it.
Those of you that have not subscribed yet, please click on that subscribe button. It'll help get this video out to more and more people.
Part 2 comes out next week. Stay tuned, only on the Jones Zone.